Mom worries about COVID-19. Court blocks dad's cottage week with the kid. In a recent urgent ruling via Zoom call, the Ontario court prohibited a well-meaning father from immediately taking his son to a cottage week with his extended family because of the mother's concerns over the risk due to COVID-19. The parents were separated and shared joint custody of their 9-year-old child, who lived with them on a weekly alternating basis. The parents were also subject to court-ordered schedules around how and with whom the boy's summer vacations were to be spent. For his scheduled summer vacation time with the boy this year, the father's plan was to enjoy a week-long cottage rental in the Kawartha Lakes area, with members of his extended family joining him. His own parents were coming from Leamington, and his sister and her child were coming from Toronto. The plan was that the three households would merge into one social bubble for the week, and thus avoiding having to concern themselves over pandemic-related protocols, such as wearing masks or physical distancing. The mother objected to this on the basis that this was selfish of the father and unnecessarily risky, since she was concerned that the child would be exposed to a risk of contracting COVID-19. With 7 family members traveling from 3 different parts of the province, she pointed out that by definition, this cannot be a social circle or bubble in accord with the provincial health guidelines. As such, she did not want the child to go. As the court explained, put another way, she did not want the child exposed to any non-compliant situation, even if that meant he was prohibited from taking summer vacation with his father. She brought an urgent motion, incidentally without giving the father the required notice, and asked the court to block the child from going. The father countered by insisting that the child's best interests were uppermost in his mind, that he was well versed in the recommended COVID-19 hygiene practices, and the risks were minimal. He accused the mother of making yet another attempt to interfere with his summer vacation plans for the 3rd year in a row. After reviewing the evidence available on short notice, the court ruled in the mother's favor. It concluded that the father's arrangements around the proposed cottage rental were insufficient to address the risks. The court focused solely on whether it was in the best interest of the child to participate in light of the current provincial health and safety guidelines. It agreed with the mother's stance that the father's current plan to add his extended family and not strictly conform to the provincial social circle directives around bubbles. Those directives were also stipulated that separated spouses should include each other in their respective social circles before taking steps to expand the circle to others. But in this case, the mother, who had asthma, objected to being part of the larger social circle with the father that he wanted, which the court found was reasonable. Plus, there was no evidence from the father about whether the child's aunt and cousin were adhering to social distancing protocols, nor anything about their own social circles. As the court noted, according to the provincial guidelines, each person can only belong to one social circle. So if a person is invited to join a social circle, their social contacts must also be considered. The court hastened to add that this was convened by both parties and taken the appropriate steps on a daily basis to keep themselves and the child safe from COVID-19 while at home. This included social distancing, practicing good hand hygiene, and being careful about grocery shopping and other outings. However, the court still drew the line at the father's family cottage plan, stating that it was satisfied the father did not believe he was exposing the child to any risk by pursuing a cottage vacation with his family. It has to be said on many occasions that these are unprecedented and confusing times. What is allowed or not allowed is rapidly evolving. In pre-COVID times, the proposed family vacation would have been a fun, happy week for the child. However, considering the current health threat, the evidence before the court found potential risks to the child outweighs the benefit of 1 week at the cottage. Not without some apparent trepidation, the court accordingly ruled that the child was prohibited to join the father on the cottage trip with the extended family. What do you think? Did the judge get this one right? Please give us the thumbs up and comment below. Share it with your friends or family. Subscribe and stay up to date on family law and our future videos. Let us know what you think of this particular case and whether or not you agree with the judge and his interpretation of social circles. So be sure to subscribe and hit the bell icon, notified when you get notification when we get new videos and posts online. Thank you for watching. I'm Russell Alexander.